of the arguments and the filing of the written addresses, they included it that they were wrong. That's the implication. That now it is just for 8,841 votes. The tribunal extensively, like you said, it was a split decision. Two of their lordships say David Umbugadu won the election with 841 votes. Then the dissenting judgment of Honorable Justice Mashi stated that Governor Abdullahi Alhaji Sule won with a margin of almost 3,700 something votes. So that is the decision between the two. Two of them examined the claims of both the petitioners and the respondents and came to the conclusion, the majority says, it is Umbugadu that ought to be declared as the winner, and therefore it was declared. That the election conducted in Nasarawa State was not conducted in substantial compliance with the provisions of the Electoral Acts, whereas the dissenting judgments claimed otherwise, that the governor was properly elected and should remain the governor of Nasarawa State, and that the election was conducted in substantial compliance with the provisions. So the dissenting judgment dismissed the petition of the petitioners.
Mm-hmm. Now, thank you very much. Now, the lordships were actually, they necessarily had to deal with the same evidence before the court, before the tribunal. And I suppose this is why, tribunals are peopled by, an odd number of judges, so that you can see it. If it's 5, then it's not possible to have an equal deuce kind of a situation. The governor and APC in Nasarawa State has said immediately that it's going to be appealing. From your point of view as a lawyer yourself, how come, well, it's not so much how come, what do you think was the reasoning? Because that Justice Ibrahim Mashi, had said that his learned colleagues, that was their opinion, and so we had that split decision. But he needed to put it on record that, as far as he was concerned, the case lacked merit. And that was, I thought that was particularly strong language. It lacked merit and failed to prove the case of the PDP. So, as I said, same evidence before the lordships, one seeing it so differently. What, if you were to hazard a guess, what do you think it was that they shall now be taking to appeal? Because they have signified that they will be appealing.
Thank you very much. After the respondents were served with the copies of the petition, naturally, in an election petition, because we see election petition is sui generis, meaning that it is a class on its own. We represented the governor, the second respondent, and we filed series of preliminary objections to the competence of the petition, and also answered the petitioners in respect of all their allegations. Thirdly, the second respondent also came out and said, since the petitioner were challenging that some of the votes were excluded, that the vote of the second and third respondent, that is the governor himself and the APC, were also excluded. Additionally, in compliance with paragraph 18 of the Electoral Act, which says that a respondent can also object to the vote of the petitioners, we also objected to the votes of the petitioners, especially naturally in the areas where they are on diverse grounds, including overvoting, non-accreditation, etc. Now, like you said, one of the reasons why we consider it very strong to go on appeal Let me take it from the preliminary objection that the second respondent, I'm speaking for the second respondent now, filed. Okay. Or the counsel on behalf of the governor filed. Like I said, the election petition is sui generis. We have said that the prayers in their petitions were ungrantable. I won't talk like a lawyer now. Let me come down to the level of a layman.
Oh, okay.
Sorry,
so that's not necessarily a legal term. That's not necessarily a legal term, ungrantable. You say you're not speaking as a lawyer and using that word.
No, I want to just make some kind of analysis. In an election petition, if you are challenging that the election conducted in Nasarawa State on the 18th of March 2023 was not in compliance with the provision of the Electoral Act, naturally, you need to seek that election which you claim was not in compliance must be nullified. The petitioners never asked the tribunal. There was no prayer as to the nullification of the election, because you have alleged that that election was not in compliance. And that was the decision of the tribunal. The majority decision was also that election was not in compliance with the provisions of the Electoral Act, the manual, and the guidelines. Now, if that is the case, should the petitioners not have asked for a prayer to nullify the election conducted on the 18th day of March? This is very fundamental. The part of the reliefs they brought was, withdraw the certificate of return of Governor Sule, and then declare Obudu, and it should be sworn in forthwith, which the tribunal granted. But because the election petition is sui generis, having not asked for that prayers, and we say the courts and tribunals are not Father Christmas, we have stated that this is very, very cardinal. How can you issue a certificate of return to somebody and you never sought for the nullification of the election of the sitting governor? You know, it will create chaos. We have brought all these arguments, they were argued. Another point, which is also very important here, is an election petition. We have what we call grounds of the election. They are just like foundation. And the fact that you build on those grounds must not be incongruous with the grounds that you have. For example, the petitioner's only ground, the sole ground of the petitioners, was that Governor Sule did not win by a majority of lawful votes cast at the election. This presupposes that any fact relating to non-compliance, relating to non-qualification, or relating to malpractices or corrupt practices should not be built on that sole ground of not winning by a majority of lawful votes cast at the election. We have also objected to this, that this is not possible. Since you came with just only one ground, all the facts must be built and must not be incongruous with the ground of the petition. The tribunal, in its wisdom, glossed over. We have very potent preliminary objections. Part of what the tribunal said, why it glossed over it, was that our objection was just too technical. And technicality is part of the law. Why are we lawyers? Also in an election petition, which we say it is a class of its own. If your facts that you have led, evidence you have led, were in support of the ground of non-compliance with the provision of the Electoral Act, naturally, all those evidence should be demolished. The petitioners allege in several polling units that the election was not conducted, because if you say there was overvoting, you are trying to say that the total number of votes cast exceeded the total number of accredited voters in that polling unit. And that means that you are alleging that, yes, there was non-compliance with the provisions of the Electoral Act. But as I'm saying, the only ground of that petition was just on the fact that Governor Sule did not win by a majority of lawful votes cast at that election. So we have brought series of objections that naturally or ordinarily should even demolish, or there are jurisdictional issues that we believe that having reviewed, examined all these objections, the tribunal should have come to a conclusion that these objections are put and the petition hereby dismissed. The only thing the tribunal said in just 2 paragraphs was that this election petition is, they agree that it's sui generis, but however, that going to determine that preliminary objection will be like emphasizing on technicalities, which will not be in the interest of substantial justice. That was all. Now, another thing that I told you, that the petition, the respondent also claimed that some of our votes in certain units and wards were reduced. We brought in witnesses. In the third allegation, that we also objected to the vote of the petitioners. We brought in witnesses with tender document to show that there were certain areas where there were overvoting. And these were areas where the petitioners won overwhelmingly. In those areas, tribunal just disagreed with us and entered judgment in favor of the petitioners. So I believe that these are some of the major grounds that we are going to test at the Court of Appeal. Another very important one, before I go, is that we said, in Chiroma Ward, in Gayam Ward, Chiroma has 102 or 103 polling units. Gayam Ward in Lafia has 58 polling units. In Chiroma, the petitioners called only just one witness, who was the ward coalition agent of the party. He came, he testified. At the end of the day, in his depositions, the evidence he gave in court was that all the things that transpired at the various polling units were narrated to him by the polling units who were never called. No single polling unit was called in the whole of Gayam Ward. No single that has one polling unit. They called only just one single witness. No single polling agent was called in the whole of Gayam Ward. None was called in Chiroma Ward, like I said. We said, come, this is not possible. The evidence will be tantamount to hearsay. But the tribunal said no, surprisingly, that the evidence of the petitioners were purely documentary. They relied on the provision of Section 137 of the Electoral Act, which the Supreme Court has even whittled down in case of Oyetola and INEC. That the case of the petitioners was just documentary, that even if they called just one single witness for the whole case, that would be enough for them. Say, come, that Section 137 of the Electoral Act being referred to, talk about non-compliance. That provision says that where you are alleging non-compliance and you have brought originals or certified true copies of documents, it shall not be necessary for you to call more than maybe one witness. Like I said, the petitioners include a ground of non-compliance, because that provision is, 137 is talking about non-compliance with the provision of the Electoral Act. It therefore presupposes that even if you want to invoke that provision of Section 137, the petitioners ought to have come under the ground of non-compliance, added to the only ground that they brought. All these things were argued.
Thank you very much.
The wisdom of the tribunal.
For interrupting you. Thank you very much. Thank you. And also for simplifying it so that ordinary people can understand it. But let me bring on Mr. Mahmoud, who has called in from Lagos. Thank you for holding on, Mahmoud. Go ahead, please.
Yeah, good morning.
Good morning.
Yeah, I'm not a lawyer, but as somebody who is educated, from what Dr. Mubarak is saying, there is no way. There are 3 judges, and then 2 was for Ombugadu, in favor of the rule in favor of Ombugadu. And then the other, the third one, Judge Mashi, ruled in favor of APC. From the evidence before them, I don't think they erred in law. They gave to the person who won the majority votes, as far as we are concerned. Because what I've been having in Nasarawa State is a one-man show. I just want to digress to what happened during the National Assembly election. Two factions, somebody had election in one area, another faction had another area, and the governor was saying that he cannot work with somebody. What the governor came to say, sorry to take it back. Governor was saying that he cannot work with the person. He can only work with Buhari. What sort of democracy is that? Look, these are our leaders. They will set this country on fire one day. I wish him good luck, and I wish Dr. Buhari good luck. You can go to appeal, you can even go to a Supreme Court. God will bring the actual winner of the election. Thank you very much.
Indeed, thank you very much. So, as I was saying, Dr. Adekileku, well, the part that most people will be able to grab hold of was the point you made about the petitioners alleging that the conduct of the election and the victory of the governor was not in substantial compliance with the Electoral Act. But you did point out something that we've heard lawyers say over and over and over on our programs, that the courts are no Father Christmas. And that if you haven't asked for a thing, it is not their business to be going shopping and saying, how about this? Don't you think this is also useful? Don't you think this is... They say that's not what the courts do. They limit themselves to what is before them. And so I suppose many people will be able to relate to that in a non-technical sort of way, waiting, of course, for the appeal courts to pronounce on it. But they'll be able to relate to that, I was imagining. The point you made that they were that very... as you explained it, that some substantial non-compliance would appear to now be good in as long as you strip one of the office, of the spoils of that victory, and then hand it to another. Isn't that still under what has been alleged to be a substantially non-compliant election with the Electoral Act? I guess if you didn't know anything about it, just going by what you have explained to us, that would be something that their lordships will have to also determine whether it is possible for the non-compliance to fault one man but benefit another.
Thank you very much. That's one of the major areas where we are faulting. Of course, like I always say, Tribunal, a majority decision says Umbugadu is the winner. Until it is set aside, that is the law.
Yes.
The dissenting judgment, even though it says Governor Sule is the winner, it is a minority judgment. That is not the majority. But Electoral Act gives any respondent whose election has been annulled 21 days within which to appeal. So, as I was saying, one of the most important things in this is, you have said the election did not comply with the provisions of the Electoral Act. There was no ground for non-compliance. The ground, like I said, they are the foundation. If the foundation is not properly erected, there is nothing you can build on it. You cannot build something on nothing and expect it to stand. And that's why lawyers always, people always look at lawyers and say, maybe lawyers, they are not. These are law.
Okay.
And we
let me sorry to interrupt you again. Let me bring in Mr. Mohammed, who is calling from Abuja. Good morning to you, Mohammed.
Good morning, Uncle Yori. Good morning to your guests.
Yes, thank you. Good morning.
Yeah, thank you. My only question, did the petitioners been able to bring evidence in court? Have they been able to bring the evidence in court? Because some of the information we had is like they just rely on IREF, the way Osun State Tribunal rely on, and then gave judgment to the petitioners. Later on, the judgment was cancelled. The victory was cancelled in Court of Appeal. Did the petitioners be able to bring evidence the way APC brought evidence in Kano in court? That's what I want to find out. Because they cannot rely on IREF, because the presidential election too, they say they cannot rely on IREF results to declare somebody as a winner. So how can Nasarawa case be different with other cases, other states? So that's my question. Thank you.
Thank you very much, Mr. Mohammed, for bringing it. Okay.
In law, there is what we call ser decisis, or we call it the rule of judicial discipline, that the judges are also bound by the decisions of the appellate courts in whatever other decisions they want to take. The petitioner subpoenaed some witnesses. At least most of you in recent, was it 6th of September this year, that the Court of Appeal decided the cases of Atiku, Abubakar against Bola Tinubu and INEC and others, and also Peter Obi. One of the major decisions of the Court of Appeal was that subpoenaed witnesses ought to have filed their written statement on oath, and that their names must have been listed with the petition within 21 days of presentation of the petition. Same thing happened in Nasarawa. All the people that brought that IRF that he was referring to, they were subpoenaed by the petitioners. We cited the case of Obi, Peter Gregory Obi, against INEC to the tribunal. Surprisingly, the tribunal just didn't even refer to it. The tribunal started citing the cases of Olubumiete, the cases that were decided early in 1990 or 2000 or something, with the recent decisions of full court of the Court of Appeal. That would have been a nice cleaning exercise. All the evidence given by the subpoenaed witnesses, either from INEC, and let me tell you, the petitioner subpoenaed witnesses from PRP, People's Redemption Party, and another one. They were subpoenaed witnesses. They also subpoenaed witnesses from INEC who brought in IRF copies. Almost all the IRF copies were brought in by subpoenaed witnesses. We cited the case of Peter Obi and Atiku, that all their evidence and the documents brought in by them, because if the court says, come, you are not entitled to testify, then all the documents brought by you should also go. We cited all these ones, the tribunal didn't even refer to it. And that's why I say there is what we call the doctrine of stare decisis, that the binding force of precedent. Once you have a precedent by an appellate or higher court, you are bound to follow it. And that is where the issue of judicial discipline comes in. That is, those are part of the grounds. Now, the petitioners brought in an attempt to prove.
Hold on. Can you hold on, please, while I bring on another caller who wants to contribute to the program? Sorry for that. Good morning, Mr. George.
Good morning, Uncle Yori.
Yeah.
Good morning to your guest, too.
Yes, Dr. Mubarak.
Uncle Yori, I think the National Assembly needs to tinker with the Electoral Act, because the elections are beginning to take a new dimension in Nigeria. It's like the judiciary is about to replace INEC. We shouldn't allow this trend to continue. How do you start talking about overvoting in an election where beavers machines were used? You remember that was the same thing, the same allegations that were made in Osun. INEC insisted that there was no overvoting, but the tribunal, said there was overvoting, only for them to get to the higher court, and the higher court said there was no overvoting. I think the credibility of INEC should be improved, or we should rely on what INEC is saying, except that there are strong evidence to show that what INEC is saying is not the correct thing. But for the judiciary to be using technicalities to determine the fate of a governorship election is risky. So there is a need for the National Assembly to take a second look at the Electoral Act, so that it doesn't, when people lose elections or win elections, they should learn how to accept the result of elections. If I were the National Assembly, I would put a clause in the Electoral Act that if you are protesting that you are the one that won, and you get to the court and you lose, you pay a fine of not less than $1 billion. So it is only those who really have a case that we want to pursue the case in court. The way the things are going now, we are looking like a country where there is no trust in our electoral system, there is no even trust in our judicial system, as if this is just anybody's game. It's not a good trend.
Okay.
That's my view.
Thank you very much for calling in, Mr. George. Dr. Mubarak, let's just take a break now. We'll be right back to continue with this conversation. Stay with us, please.
Politics is defined as getting what, where, when, and how. But in the mix, many things come to play to shape the political fortune of any country.
Mr. Honorable Minister, that's how you misinform the public.
From the political actors to the electorate, campaign to voting, from debates to policy decisions, big events happen to engage us in constant conversation.
That's what we're looking for. Not some people who are talking about ethnicity. No.
Who is on your mind?
Don't worry.
Join me every day on Politics Tonight, where we dissect issues that shape our political destiny. Politics Tonight, weekdays on TVC News.
Okay, welcome back. And if you're just joining us, we're looking at the topic of the tribunal sacking the Nasarawa state government, Abdullahi Sule of APC, and instructing INEC to withdraw his certificate of return and issue same to the petitioner, in this case, PDP's David Ombugadu. It was a split decision. The chairman of that particular tribunal, Justice Ezekiel Ajayi and Justice Chiemelie Anaga, they were the majority component of that decision. But the dissenting judgment was delivered by Justice Ibrahim Mashi, who says that the PDP's case lacked merit and failed to prove what they were indeed demanding, and upheld INEC's decision. Now, Dr. Mubarak Adekilokun is our guest in our Abuja studio. I don't know if you wanted to comment at all on the point that that last guest before we went on break made, that is George calling in from Ikeja, that he seems to be concerned that the courts, and I've heard lawyers or even knowledgeable people who aren't necessarily lawyers, when they are having these kind of conversations, have been concerned, are apprehensive that the court system is taking far too much of far too much of a role in the decision of our petitions, and he feels that it is worrisome. I don't know, without prejudice, do you have any impressions one way or the other on that particular point?
What I only have to say, because he commented especially in relation to what constitutes overvoting. The Supreme Court has settled it clearly in the case of Oyetola and INEC, that for you to be able to prove the allegation of overvoting, you need three things. You need the BVAS machine, you need the voters' registers, and then you need the result of the polling unit, which is even far more reasonable. In the Electoral Act, they only said accreditation based on BVAS and the polling unit results. But the court has said, these BVAS computers, they are susceptible to errors. I was part of the team at the trial during Governor Adeleke's petition. One of the major issues raised was that if you use a BVAS machine, for example, in a village that doesn't have internet, it is until you click the send button before the figures will have to go into the back-end server. Now, let's assume that you did it in village A that has no network, because these things work with network. You did it in village A, it is until you get to where network is. And it is possible you don't get network the following day, and you have to submit the BVAS machine itself to INEC. So it is possible that some BVAS machines will be submitted without sending the particulars, the total number of accredited voters, into the server. So these are they are susceptible to errors, technical glitches. And that's the reason why Supreme Court has said, come, don't only base determination of what overvoting is on BVAS machine, because by the name, it is just a machine, can fail at any time. So also look for what we call, we also have to tender what we call the voters register, which we have been using before. Those are registers. It should be shown whether the total number of registered accredited voters were ticked on that voters register. Then you also have to look at the EC8A, which we call the polling unit results, because it is in that result that you get how many total valid votes, total rejected votes, and others. So you have to match them or compare them with the total number of accredited voters you have in that your BVAS machine and the voters register. So Supreme Court has settled it. So it is no longer whether National Assembly says something, Supreme Court says something, and what the Supreme Court has said is even far more reasonable. So this has been settled judicially in Nigeria, that for you to prove the allegation of overvoting, you need the BVAS, you need voters register, then you need what? The EC8A result of the particular polling unit.
So you and your party, APC, you differ with the chairman who I just spoke about, Justice Ajayi. You differ when he declared that Mbugadu provided the results of the various polling units and forms EC8A and proved to the tribunal that the results were manipulated in favor of the APC.
Of course, definitely we differed. We tendered barrage of documents too, pointing towards the fact that Governor Sule won this election. That it was not Emmanuel Mbugadu that won the election. And it's their wisdom. If you read the dissenting judgments, these facts issues were critically dissected and analyzed by Honorable Justice Machi. If you look at the majority judgments, they only made some references to it. At the end of the day, they entered judgment completely for the petitioners. Let me tell you one very important point, which will also constitute our grounds of appeal, is that the tribunal in its majority judgment says PDP won, Mbugadu won with 293,287 votes. That's after the entire addition and the subtractions. And then Governor Sule won with 292,446. If you deduct this from the PDP votes, you'll be left with a margin of 841 votes. So from the majority decision of the tribunal now, which is the law, that David Mbugadu won with 841 votes. Now, the tribunal nullified the results of 4 polling units based on overvoting. 4 polling units. These are Boha Serki in Akwanga, Kofa Magaji in Nasarawa, Gadabuke and Ihampe. The 2 of them are in total local governments. If you look at the total number of accredited voters of these 4 units, it gives us 911 votes. 911 total number of accredited. Whereas the margin of win, of lead, as described or as declared by the tribunal, between PDP and APC is 841. Where do you put or keep the margin of lead principle? It is there.
Okay. Let me bring in...
sub 3.
Let me bring in Mr. Lalekon, I beg your pardon, who has called in from Ikorodu and indeed has held on for a while. Thank you very much, Mr. Lalekon. Go ahead, please.
Okay. Hello?
Yes, good morning. We can hear you. Go ahead, please.
Okay. Good morning, sir.
Carry on, please. Don't listen to the feedback, the echo. Carry on, please, Lalekon.
Okay, good morning, sir.
Good morning.
I've been hearing all what our lawyer have been saying and Uncle Yori. The only thing here I want to add to is that why can't you just forget about using beavers during the election? Since the election we are doing in Nigeria now is not transparency. You understand? We can just go back to option A4, the one we did during the SOFA and MKO. But the election in Nigeria is not transparency to anybody. Why can't you just let's go back to option A4? Then there'll be no going to court after election. You understand? Because all these things, the lawyer said they want election to be nullified and they will be collecting money from all those people. Let's go back to option A4.
Okay.
Whether you are voting for AB, then you just line up. See, you just line up. Immediately, everybody will know their results. Nothing going to, nothing like beavers or this thing.
Okay.
The only thing I think, this Nigeria, they are not transparent with any election. Let's just go back to option A4.
All right. Thank you very much for your contribution, Mr. Olalekon in Ikorodu. Well, the train has left the station and people seek to improve, and I think that is the... But let me allow the lawyer, Mr. Kilekun, respond to that. That's ancient history. We can't go back, can we? But I think Olalekon was relating intricacies that we now have to contend with, and probably saying that life used to be a lot simpler at a certain time.
I think, like he said, some members of the National Assembly who are the lawmakers are also hearing us. Maybe in case they decide in future to amend the provisions of the Electoral Act. There have been a series of arguments for and against the adoption of option A4. I also remember that when I was young during MKO's regime, I was part of those that went to visit even though I was less than 18 years then, where elections were being held, and it was very interesting. So it's a matter to be decided by the National Assembly whether there is any need for Nigeria to adopt the option A4. But now, what we have is the secret ballots. That is what is still being used in Nigeria for now. So as I was saying the other time, that Section 51, sub 3 of the Electoral, I have the Electoral Act here. I don't want you to look as if Dr. Adekilekun is manufacturing some provisions of the law. It provides that where an election has been cancelled, let me read it out. Where the result of an election is cancelled in accordance with the subsection, that's subsection 1 of Section 51 on overvoting, said there shall be no return for the election until another poll has taken place in the affected polling units. Assuming without considering that there were overvoting in those 4 polling units. And we have seen that the margin as declared by the majority tribunal is 841 votes. The total number of accredited voters in those areas is 911 votes. The total number of accredited is far more than the margin of lead between the two. The Electoral Act said there shall not be any return. The worst is for the tribunal to say, go back to these 4 polling units to go and conduct a rerun election, to now fully determine who has won the election between David Ombugadu and Governor Sule. The tribunal also glossed over it. They didn't even say anything about it. These are part of it. We have seen situations in Nigeria where rerun has been held. Tribunal can declare, go back, since we have cancelled the election in 4 units as a result of overvoting, and the margin of lead principle has squarely come in, go back and do rerun election because we only have 841 margin between.
But they didn't so declare.
That has been declared.
And these are part of the things that you are contending. Good morning, Ahmed in Niger State.
Good morning.
Good morning, sir.
Good morning. Dr. Mubarak, good morning.
He can hear you. Please continue.
So, I don't know. Nigeria now, my contribution goes to that. Judiciary want to take the position of INEC now. Because in Nigeria, we don't have a constitute body again. I think that the judiciary only interprets, not to decide. It's just to interpret the law. But we don't know. Look at the case of Kano now. It has come to a fumble that the judiciary don't have a sanctity, a judgment that would be relied on. I beg, and Dr. Mubarak, I don't know. Nigeria, we are fed up with judiciary. They should rethink. Otherwise, if not, judiciary have made of what you call a hope of ordinary man. Because if INEC have taken a decision, this position of INEC and the Act, Electoral Act, testify that along the line, judicial intervention want to take what belongs to INEC or the position of INEC. Oh, that is what's bothering me.
All right, then. Well, thank you very much for calling in. But let me just say here that in reacting to the decision of the tribunal, Mr. Ombugadu's lawyer, Mr. Johnson Usman, S.A.N., he actually lauded the judgment, and quite frankly, he was pleased with the fact, he said that this proves that the judiciary is the last hope of the common man. That was his position. You might say that, of course now, necessarily, but I'm just saying. Now, I wanted to ask you, as a lawyer now, the concerns that are being brought up, it might not necessarily, it doesn't have to refer to this case, but the point that Ahmed from Niger State made, that the tribunals, the judiciary is not to decide, it is only to interpret. As a lawyer speaking to non-learned people, what would be your comment on that particular assertion of his for education?
Well, you know, the primary role of the judiciary is to adjudicate. That's what Section 6 of the Constitution says. When a legislature has made the law, if there is any dispute between either any of the agencies or layers of government or individuals or among individuals inter se, and you have brought a matter before the judiciary, they interpret the law and give effect to it. And interpreting the law, whatever conclusions they have come into, that is also the law. Like the Oshun that we are talking about now, the Supreme Court in its wisest, in its wisdom, has stated that even though accreditation has been referred to in terms of the beavers only, the reason I just explained to you that there could be technical glitches, is it not substantially enough for the Supreme Court to say, voters register is also very cardinal, because that is the manual that we use up to today or to tomorrow. If you base determination of what constitutes accreditation only on beavers, yeah, it is possible there is no server. It is possible that the copper that was appointed as the presiding officer had even submitted the beavers machine to INEC without uploading.
Okay.
And you have gathered a lot of voters to come and vote in a particular polling unit. They have wasted their time from morning till almost evening time. So that's why Supreme Court has added. See, these decisions are, in most cases, very reasonable. That instead of leaving it only to be determined by the beavers, why not also use voters register? So if you know that you want to contend that there is overvoting in a particular polling unit, there is nothing bad in you to get the beavers, voters register, and the polling unit result. So it's so simple. So it's not only that the Supreme Court or the judiciary interprets the law. They interpret the law, and in the process of interpretation, they arrive at firm decisions, which will now constitute the law.
All right. Okay, let me bring in Emmanuel calling in from Jigawa State. Good morning to you, sir.
Good morning, sir. Good morning, doctor.
Okay. Go ahead, please.
Okay, I want to contribute towards the election, what happened in Nasarawa. I think the judge have actually done justice to this. Because the lawyer is talking about the ground. When we are talking about ground of election, by the Act of 222, it stated that election collects from polling units. I think the petition have proved enough by tendering the result from polling units, from IREP, from Beaver. They have proved their case beyond doubt. So they have actually won the election. What the tribunal did is the justice for the masses of Nasarawa State. We will not be comparing the election that happened in Nasarawa with Kano. It's far different. And what happened in Osu is far different. If you are in Nasarawa State, you actually know that what takes place, PDP have actually won the election in clear terms. It's just that overvoting in Gayam watch, overvoting in Chiroma watch. If you look, the House of Assembly election and the governorship election was different entirely. So in time of justice, this is an open justice to the masses. So I think that the APC or Governor A. Sule should accept defeat. Going to appeal is waste of resources of Nasarawa State.
Indeed. Well, thank you very much for calling in. As I was saying, the lawyer to the petitioner has seen it the way you have seen it, but then the law is arranged in such a way that you have another opportunity. Should you be in disagreement with anything, take it up to a higher court where it shall be pronounced upon. But thank you very much for calling in, Emmanuel, who was calling in from Jigawa. Okay, interesting, because Justice, just to in case you've heard about it already, but it was Justice Ezekiel Ajayi, who was the chair, and Chiemelie Onaga, who had given that split decision, saying that the Governor Abdullahi Sule of APC, should vacate the seat, and indeed INEC should withdraw his certificate of return and hand it to who they had adjudged to be the winner of that election. And Justice Ibrahim Mashi III was the only one who saw it differently, and so we have a dissenting judgment, which I have read that APC in Nasarawa is in full agreement with, but this now has to be tested when you take it forward. And I'd like to thank very much our lawyer, the lawyer on our program here, Dr. Mubarak Adekilukun, who has been explaining it to us. And also, there's not very much need to, because the lawyer for who the tribunal has now given the decision to, he's always said that the judiciary is the last hope of the common man. And, this indeed is as he wanted it. But not so, say, those who will be appealing. How much time, when will this be decided now, when you take all of these that we've been listening to from the beginning of the program, when will this now be taken to a higher court?
And the law is that we have 21 days within which to appeal, and then as soon as I'm sure the notice of appeal is ready, it will be filed. So the appellant now have 7 days within which to file brief. Respondent has 5 days. Appellant has 3 days within which to reply. And it is the sole discretion of the President of the Court of Appeal to constitute a panel to hear. So we can really not say when it will be heard. But the Constitution has given the time frame from the date of filing of your notice of appeal to the date of delivery of judgment. You have 60 days maximum. The Supreme Court has described it like a rock of Gibraltar that cannot be shifted. You can't move a day outside of these 60 days. So certainly, as from the date of filing of the notice of appeal, you have 60 days within which the Court of Appeal shall determine the appeal of the appellant.
And all that while, Governor Abdullahi Sule of APC is in place, right? He's still in place, carrying on his duties.
He is fully on ground in the office, and continue doing all his developmental projects in the states.
I want to thank you very much.
After 21 days, yes. Thank you.
Thank you very much, Dr. Mubarak Adekunle, for explaining the case to us. All right, then. So that's our program today, and please join us tomorrow when we shall have another topic for consideration. Until then, I am Yori Folarin. Bye-bye for now.
Presentation by ShopX TV. Are you worried about the safety and security of your home at night? Do you wish to know when intruders come close to your home? Or do you want to protect what matters to your family from anywhere at any time? What if there was a convenient, affordable way to keep surveillance on your home without having to worry about wires, installations, or heavy light bills? Introducing the incredible Sidebulb HD Cam, the robotic 360-degree two-way torque camera with action tracking technology. Sidebulb is the ultimate solution for discreet and